The court in some instances makes orders which affect where a person lives or resides. Today on Law Express, we'll be discussing occupation orders. We'll go for a quick commercial break. When we come back, you get to meet my co-panelists for today. My name is Noella Seidu, and you're tuned into Law Express.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea butter. Feed your skin right.
Kobna Frimpong Mensah. Kobna is a legal practitioner and he enjoys reading and watching football in his spare time. Bobby Banson. Bobby is a legal practitioner and he likes to swim and play football. Noella Seidu. Noella is a private legal practitioner and a consistent member of our 3-lawyer panel on the show. She plays a dual role as the host of the show and likes to play tennis and read.
Domestic violence is something that we hear a lot in newspaper reportage, and we hear it in a lot of discussions that come up. I must say that since the law was passed, which is almost 15 years or so now, we've had a lot of people coming out from their shelf to take advantage of the remedies or the avenues that have been provided under our law. And it's for me, it's one of the feathers in our cap as a country that we have an act that specially deals with persons in that space. So the use of the word domestic, it's there to connote that it is not available to any person. And so people have asked, okay, if I slap somebody, is it not a criminal offense? Why should there be a different law to cover that? I think it's because the framers of the law know that in certain situations, because of the relationship between the parties, so father, mother, children, spouse, wife abusing the husband. Well, I know people will be expecting me to say husband abusing wife, but wife abusing the husband, we have to break the bias in every way. So the law has provided for those avenues where even within the criminal delivery system, where a special unit of the Ghana Police Service has been established to cover for these things. So I think that it's a very good point that you have, for example, decided to discuss domestic violence, as it were, and then go further to discuss some of the remedies available for people who become victims of such domestic violence. So it's one in the context of domestic violence is in the context of people within a certain relationship as provided by law and certain acts that may be considered to be violent to the victim.
To better situate this conversation, there will be a need to find out which relationships are declared or deemed to be domestic in nature. So the most common examples are the normal family setting, as Bobby rightly said, father, mother, children, grandmother, or uncles and aunties, depending on how close the relationship is. Has also included a house help and household relationship in its definition of a domestic relationship. So if you've been fortunate enough to have somebody come from the village, as we always do, to come and stay with you, and you abuse the person in whichever way, it falls squarely within the ambit of the provisions of the Domestic Violence Act.
Okay, now we've talked about what the domestic relationship is. Let's bring in the violence bit. What kind of violence are we looking at?
So the Domestic Violence Act looks not as acts already perpetuated, but the threat of those acts being perpetuated
as well
is also taken into consideration, whether or not you're falling foul. So there are various kinds of domestic violence. I like to use the word kinds. But the first one is that any act which falls within the ambit of the Criminal Offences Act, which is done to somebody within that domestic relationship, is domestic violence.
Yeah.
That is physical violence or the threat of physical violence, confining the person to a space, false imprisonment, depriving the person of access to food, shelter, anything that violates the human dignity of a person is domestic violence.
Thinking through it, or whenever I read this, I have two questions that I don't see answers in the Act. The first one is that there is no express provision, even though if you have a purposive interpretation, of the Act being applicable to what we would call boyfriend-girlfriend situations, where you hear a lot in the media these days that they are not married, they are not related by blood, they are not family as defined yet, but a girl goes to visit his boyfriend for a weekend, and then she leaves with bruised faces. Would that come under the Domestic Violence Act, or
so.
you'd go?
Yes, it does,
so.
because in consideration for protection orders, which come before occupational orders, there's the consideration for people who are in courtships, people who are in relationships where even they live together, though they are not married. So then, in effect, cohabitation, any relationship that involves some form of intimacy falls within the ambit of a consideration where the court is giving any orders. So you can say that normal boyfriend-girlfriend relationships.
I also want to
people
believe
have
that
perception that it's not applicable to those kind of situations.
There is also the aspect of the Act which talks about relationships that exist or have existed between the parties, which suggests that even an ex-boyfriend or girlfriend may fall in there, or an ex-husband.
Yes.
You know, so I think
it's
that I see where you're headed, because you just want us to explore the conversation further, to let our viewers know that even where it's just a relationship and you are visiting in and out,
exactly.
it's still
covered,
fall,
yes. So that people will know that it can still be treated as such with all the punishment that comes with it.
So we've talked briefly about what domestic violence is, just to organize this conversation and situate it in a particular manner for the benefit of our viewers. We know that mostly if you offend this act or you go against our law in the scope of domestic violence, you're likely to attract a fine, jail term, or both. And then, in addition, there could be some orders like Bobby earlier said, occupation orders, protection orders. Can we now just move straight into what these are?
All right. The Act defines the courts as either the districts, the high, or the circuit courts, and empowers it to make certain orders for the benefit of the complainant or whoever brings the complaints of domestic or being abused domestically. As part of those powers, the court has the power to order that a party leave the matrimonial home or any other home that parties were occupying together at the time the domestic abuse event occurred.
Okay.
The policy direction behind it is to protect the complainant from the threat of any other possible harm or from continued harm to him or her if they are still living together. So those are basically what occupational orders are.
Wow.
I think that it also comes in situations where the victim has no other place of abode. It's very easy, or it becomes more practical. So where the victim is in a less or in a weaker position. So the best example would be where she's the mother of your kids and then you continue to physically or emotionally abuse her, she cannot leave the kids there and leave. If it was only her, it would have been easier. But with the kids, she cannot move the kids with her to go and stay somewhere else. So the law anticipates a situation where the man, if the man is the perpetrator of this offense, would rather be asked to leave the house so that the mother and the kids, and this is without prejudice to whatever is the main source or cause of dispute between them.
Yeah.
And so in situations where they live together, they have, there are divorce proceedings. The court cannot, until the divorce proceedings has ended, maybe order one person to leave the house. But if in the course of the divorce proceedings, for instance, the woman feels that her life is under threat because of the words or the actions of the man, then the woman may apply to the court. And the law even allows for ex parte applications, that without serving the other side, as long as you're able to prove that it's urgent and that there's real threat, if you serve the other side, it will be worse, the court may allow you to remain and the other side to leave. But you need not wait for divorce proceedings to even bring such applications. You can bring that applications when you are not even seeking for divorce.
Yeah.
It may be a fair stage to get some form of protection or separation for you to be able to see if the next step would be to apply for divorce. But even though it's allowed, the courts do not just grant it. There are certain conditions that you must meet before.
I like the fact that you all keep saying that this would only come as an order from the courts. I don't want viewers to be misled into thinking that so your spouse or your partner or somebody you live with, your brother or sister, abuses you, and then you have the right to throw out their clothes, like normally what is shown in the movies. You know, especially in North American movies, there's a problem, there's a disagreement, the man goes to work, the woman packs his things, puts them in his car, like, that is Hollywood.
Or throws them off the window.
Throws them, or damages the clothes, like bends them up, and then it's like, it's normal. No.
I mean, the Constitution protects or provides for our right to property, our non-interference with our privacy. If I'm a man and I live with a woman, either as husband and wife or even siblings, or parents and child, or auntie, uncles, even domestic help, it means that I have some right, either equitably or legally, to remain within that space. And once that is there, it means that that right is protected by the Constitution. And I cannot be denied of that right except by due process. And the due process provided is not even the police officers who can ask you to leave. The police do not have that authority without a court order insisting that an alleged perpetrator of a domestic violence act should leave the space. They can do that only by a court order. And the law has provided the lay down condition. Somebody would say, what if the person is threatening to kill me today? And then, yes, your first step would be to make a report to the police. The police have the right to arrest the person.
For that
the arrest would be a temporary respite, because if the person is arrested, it means the person cannot come home. You can adopt that procedure. And if the person is arrested, you can go by an ex parte application to the court, which you can obtain within the shortest possible time, to say that this is happening, the person has even been arrested, and I'm worried that if he's released back from the police or if he's given bail, he will come home and then attack me. And you can show evidence, because there are some men and women who would even be angry, and you've gone to report. Now I'm coming back. What can you do? And they will come back worse. And then so quickly
come back more angry.
More angry. What did you achieve? Okay, the police arrested me. They couldn't keep me beyond 48 hours. I've been granted bail. Now you see where power lies.
Who is the boss?
And if you don't take care in the night when you are alone, then they would harm you. So the law provides that in such situations, you can quickly run to the court and get an order. And that is why I'm happy the law allows for these orders to be made even by the district courts. Because some people, when they hear court, they think, oh, it's some, people with wigs and gowns, and you'd have to go if you can't afford them. But the district court has the family tribunal. which is very informal, with 3 persons, one of whom is a lawyer or a career magistrate, who may not be a lawyer, and 2 people, social welfare or other persons with experience in these matters. And you can walk to them. You don't need a lawyer
to go to a family.
You don't need a lawyer to go to the district court. You can walk to the registry and say, this is your situation. The registrar will put something down for you. You would sign. And within a matter of a day or 2, you have your order. So that by the time the person is, the perpetrator is coming back from the police arrest or being released on bail, the order will be ready. And the person, you would have some space so that the person will not come into that same environment and then continue to cause harm. So the law has made it very practicable and for persons in those situations to easily assess.
Yeah, because of the agency involved in that kind of situation. We have to go for a break now. I know the conversation just got more interesting. When we come back, we talk a bit more about this, and then we go on to discuss the considerations for the grant of an order of this nature. This is Law Express. Don't go away.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea Butter. Feed your skin right.
So in talking about the orders and how practical and easy it is to get it, it is not just practical and easy, as Bobby rightly said, but it's also for an extensive period of time. I believe the cooling off period, where you are allowed to think about whatever you are doing and whether or not it's in the right place. So an order which is obtained ex parte lasts for 3 months, after which the respondent or whoever has the order act against is given time to come to court to show why the order should not be finalized and extended for another period of time.
Okay, so generally, they say even God does not punish us without listening to us. So he came in the garden and said, Adam, Adam, where are you? He said, I'm naked. So whatever,
he deviated.
Before a judge would pass any decision, all the parties involved must be heard. That is one of the rules of natural justice.
Or at least be aware.
Be aware.
And if you choose not to show up, that's different.
They must be given notice that this is the case before the judge. And if you want to make any input or respond, then you're allowed to. But the law also allows for situations where, because of the urgency of the matter, one person can go to the court and give the court his or her side of the story, and the court can make a decision based on listening to only one side. That is what we call ex parte, without notice. But that decision that is given without listening to the other side is not, it doesn't last for long. They are time bound, so that the other side can come and say, oh, my Lord, what you heard is not actually the full truth. This is the full picture.
This is my side of it.
And after that, the court may decide to vary the earlier order or maintain it.
Great.
So that is what, when lawyers say ex parte, it means that the court gave a decision without listening to the other side.
Just heard one side.
One side. And those decisions do not last. They have time bound within which the other side must now be made aware of that decision. And he or she may decide to respond before the judge will decide, okay, I'll keep my earlier decision or vary it. Or completely set it aside.
So in terms of the Domestic Violence Act, all orders made without notice to the other side last for a period of 3 months. After 3 months, the other party must be notified of the pendency of the action and must appear before court to show reason why the order should not be varied or should not be extended. where you fail to appear, the order will be extended. An order made fully before a court in a domestic violence matter lasts for 12 months, after which the court may, on taking further applications, either extend or rescind the order. When it comes to occupational orders, because they mostly relate to family situations, the court is very slow in making the orders because it does not want to uproot the family setting in which the parties find themselves.
What God has put together.
No man should put asunder. The considerations the court will first make, especially when dealing with an occupational order, is how the person reacts to provocation or angry situations.
Yeah.
If you are someone who is fond of lashing out or you are destructive, of course, you leave the court with no other choice than to grant the occupational order, because we do not know the day the straw will break the camel's back and it will go from just blows to actually killing somebody. So then you make the court work easier for it.
So your own character testifies
your own
for you,
your own psyche
or against you.
speaks for you or against you, and how you are receptive to situations where your use of dialogue and other mediation processes will affect the nature of the order, if any, that will be given.
But I kind of find this order a bit problematic in terms of, you know, some people just have their moments of madness. So
We all do.
every day you are calm. Everybody knows that Bobby is calm, he's cool, even under highly stressful situations, until that day comes and he lashes out and it's extreme, and then it's like, we never saw this coming.
So I think that is what the psych report will come up with. Your temperament.
How can your psych report show that you are, I mean, you ordinarily are calm, cool, collected. Everybody can testify to that. They've evaluated you and you are awesome, sweet. Until one day.
Yes, so the context would be that somebody is accusing you of displaying certain nature which is violent.
Yeah.
And so if you say that my natural disposition is to be calm, and the other person provides evidence that actually no, you are not. You have done A, B, C, D in the past. Okay, ordinarily you are calm. But if you flip, it's not manageable. I mean, they say that the very quiet ones, when they flip, it just gets out of hand.
Yeah.
And it doesn't mean that you should be allowed to continue. That we read in newspapers stories of mothers beating their children almost to pulp. And then somebody will ask, how can you carry pregnancy for 9 months, and because you sent the person lost 5 Ghana cedi, you decided to beat the same way we read stories of fathers beating their wives, or husbands beating their wives because of very petty issues. So ordinarily you would say, okay, I'm calm, but once the person displays that and the victim does not feel safe anymore, the victim will then report, and the reports by the professionals will show that, listen, ordinarily you are calm, but the test we have run on you show that no, when you flip, it's not manageable.
Goes to support saying that everybody has that moment of madness.
Yes.
So we picked people's opinions on the streets regarding this topic. Let's take a listen, then we come back to continue our conversation on the considerations in the order for occupation.
Okay.
My opinion on whether someone should be removed from a house property or anything if they react violently, actually, I think it's a matter of communication. Others have anger problems, they can't actually control their anger level. So that's why we have like a meeting, and we meet as a family, you can communicate with them and let them know they acted violently. If you're trying to speak to them and you feel they are so rude and their anger can lead to something else, like when they get angry like this, they can't control their anger level. They end up destroying things a lot. That's a risk. That one you can try to remove the person out of the house. But some people, it's just a matter of communication, speaking to them, and they are good to go.
I believe a person that has been violent against another in a property should be evicted, because we are trying to avoid the likelihood of a repeated behavior. We are looking at the safety of the occupants of the property, so the person should be evicted.
If a violent person is living with people and he's causing a lot of problems, he or she should be evicted from that vicinity. First, we have to speak to the person. If his acts continue on, he has to be taken out of the community or something like that. Probably a rehab or something will do.
So I believe a person should be removed from his home or property when he acts very violently towards others. A personal experience is a man who usually gets drunk at all times in our community. He lived in the same house, he were neighbors, and then one time he got so drunk that he took a matches and a petrol and burnt our house. If not for God, we would have been burnt in the house. It took the grace of passerbys at dawn around 2 a.m. to come to our aid and rescue. So I believe when people act violently, they should separate them until they come to their senses. Maybe they have emotional or mental issues that need to be sorted out.
Those are quite some very interesting views, and we're grateful for them. So in response to them, I think the common one amongst people was that it shouldn't happen more than once. They were looking at the frequency of the act.
Yeah.
However, the Domestic Violence Act does not give that leeway for frequency. It actually caps it at just one act or one certain act. So it doesn't give the space for the frequency people are asking for. The second one, which also came up a lot, was the disposition of the person who does the act. Again, it doesn't look at previous dispositions, but it pertains to what happened at the time the complaint was made. You may be the quiet person who never reacts, is always jovial, but the one day you do react is when you become uncontrollable. If the uncontrollable act is what is captured and is the reason you are brought to court, then of course you are falling foul. So your normal disposition does not play a factor in the considerations the court has to take.
Somehow your day of madness.
Somehow your day of madness is the day you got caught. Too bad. But that is what the courts will deal with, your day of madness. So that's when, those are my general responses, that the frequency of the act does not matter. It just takes one act. I remember when I was in primary school, there was this teacher who always used to admonish us that one act of pa leads to several years of pain. So if your one act of pa is today, then that is when the law will catch up with you.
One act of what? Pa. What is pa?
But they understood it clearly.
I also noticed that a lot of people, especially the ladies you interviewed, were talking about the fact that, oh, it needs talking to. If you talk to them and they change.
And they are willing.
And they are willing. I mean, yes, it's okay, but a lot of victims that are not even alive to say their story will tell you how much they tried speaking to these persons. You know, and this may sound controversial, but our religious nature as a people sometimes foster some of these things. Because when a wife is beaten, or as for the men there, we can't even go and say it. Who are you going to tell that your wife?
There are men now reporting.
I mean, yes, now, but it's not as the ratio of the men who reports to the women is significantly
Maybe they don't
very
report to places you would hear. Maybe they report to their
but if
friends.
So let me use the example of the woman. If you are abused by your husband physically or emotionally, a lot of our women in our society will think of approaching the pastor or the imam.
Or the family head.
Or the family head.
Yeah.
To try and talk to the man. If it happens 1, 2, I mean, the first thing, they will not tell you as the first, oh, go and make a report, go and get a restraining order. Because you say, oh, let's give it to God, let's pray about
let's
it.
Call him in.
Let's call him in, let's speak to him. And then before you realize it's happened twice, 3 times, and it's getting worse. And I think that's not that we are preaching against resorting to some of these things. But once the person demonstrates that, it should put you on the red alert. Because the next time it will not be less.
It can only get worse.
It can only get worse. It's the truth. If the person slaps you today, tomorrow he will not push you.
Yeah.
He would either slap you or stab you.
You know,
it's as simple as that.
I see that there's so much fixation on physical abuse to the neglect of emotional abuse, verbal abuse. Because even your self-esteem matters, your dignity.
That comes from our social setting.
Yeah.
Growing up, the premium was put on the actual physical pain you cause the person.
Because that's where the evidence is,
Yes.
on your body.
On your body. And every form of punishment as a child or as a teenager was meant to inflict physical pain.
Yeah.
So the premium has always been on physical pain and with very little concentration on the psyche of the person, how the victim feels after. Is always the second thought. And like Bobby said, our cultural setting does not allow for the outward expression of emotion. I mean, if you're a man, the common balance is fashion, the same way.
Shedding.
Even if they beat you, they say don't cry.
Don't cry. So you are conditioned to focus more on the physical and less of the emotional. So you find that disconnect. People are not in tune with their emotions and even how to express these emotions.
Yeah.
It's something we do not take actual consideration to. So that is why the premium up till now has always been on the physical abuse or the things we can see, we can touch, the pain we can relate to, with very little emphasis on the emotions of the victim.
Once again, we need to go for a commercial break. When we come back, we explore this a little bit more, and we talk about where the couple or the parties are in a rented apartment, how issues like that or the order is to be treated and what the landlord has to do or avoid doing.
Yes.
And then we take a few social media questions and gradually we wrap up. Stay tuned. This is Law Express.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea Butter. Feed your skin right.
I've mentioned the social welfare reports, and I just wanted to throw more light on it. So the government of Ghana actually has a full-blown department called the Department of Social Welfare. Yeah. A lot of us do not think that they even exist, that they are trained professionally to assess some of these situations so that they can come to the house, interview the occupants of the house, interview the neighbors to confirm whether or not the victim's assertion or the story is right. Yeah. Whether between the victim and the alleged perpetrator, who has the capacity to move out of the house.
So your lie
would be exposed.
Would not lie, because
yes.
Thinking that going ahead of the other party is going to give you the upper hand is not automatic.
We had a situation some time ago where in the context of a divorce setting, the wife actually attempted to use this order to kick the man out for other reasons. They went to court, obtained the ex parte order, and then when the husband was served, he managed to get his lawyers to bring evidence to show that he was actually the victim, because he had been reporting these assaults on him to the police station.
But did he request for or pray the court for the same kind of order?
No, he did not. But then he was able to let the court reverse the order that was made. And then you bring in the social welfare report to actually show that the house helps who live in the house always know that, hey, madam is the kakai. She's always abusing everybody. And so the man is the quiet one. So people should not think that they can abuse this to, for ulterior motive. That is why you must satisfy the conditions. The social welfare is very key. The court would consider the family units. That is more or less, for me, the highest consideration.
Yeah.
Especially if there are young kids involved. And the mother has to take care of the kids, as it were.
Yeah.
The father works from 9 to 5. Does not have time to, or does not come.
Who is the primary caregiver?
Who is the primary caregiver? The court will consider all of these things. So it is not as if the court, without considering any other intervening factor, would just make these orders. At the end of the day, it is to protect life. But in protecting the life, we must not destroy other lives. So the court must balance the welfare of the victim with the welfare of the entire people or persons within that space.
Yeah.
So it's a very interesting or very slim line where the courts are very careful.
Yeah.
So that, for example, if the father is you mentioned issue of rent.
Yeah.
If the father is the one who pays the rent is, let's say, 1,500 cedis a month. The father's salary is 4,000 cedis a month. You are asking the father to move out and go and rent another place for 3 months, for 5 months. He comes to show that my salary is 4,000 cedis.
And apart from the rent, I still have to take care of fees
I
and
pay
all other
everything.
things. Yeah.
If you're asking me to now go and rent another place for 500 or 600 or 700 cedis, where am I going to get the
They are
money
not asking
to?
him to rent. He could go and patch with somebody anyway.
That is where the report comes in.
Yeah.
Because if the man comes to say, listen, I don't have family anywhere, I cannot be able to do. So in certain situations, we've had a compromise where if it is possible in the house or on the compound for the parties to live in different parts of the building.
So this is your area of the house.
For the meantime, the courts have
house.
considered those options as well.
Yeah.
And like you said, there's also the protection order.
Yeah.
So if the occupation order is not in the best interest of the family as a unit, the court would go ahead to give the protection order.
In addition.
To say that, okay, you live in this part, you do not go within certain meters of the person.
Yeah, the law provides for 50 meters.
You do not do this.
But you are sitting far away and you are hurling abusive words at the person on the other side.
Then if you do that, then you leave the court with no option than to throw you out.
Yeah.
Because you cannot also take, at the end of the day, like we said, the court will balance the fact that you think that, okay, because you have proven that you cannot rent a place, means that the court...
They're stuck with you.
So a judge once said, listen, if you think that is the situation, I'll ask the prison to be your home.
Ouch.
Because if you are abusing whatever, like you said, you want to stay 200 meters apart and still be emotionally or physically abusing the person, then the court will put you behind bars. Remember, there's also the criminal aspect as well. So if you are found guilty of domestic violence, the court has the right to put you behind bars. So if your actions are persistent and consistent, despite the attempts by the court to just, in the interest of the family unit, protect you and you still, the court would know that you would say that you are taking, it's even contempt of court.
Kwabena, do you want to talk about the role of the landlord in this whole dynamic?
Yes.
Where perhaps the one who actually has the tenancy agreement
is the one
who's been kicked out.
Yes, so the Act protects the applicant in this situation. Where you are not a party to the tenancy agreement and the party to the tenancy agreement has been asked to leave the marital premises, you, the landlord, are forbidden by law from evicting that person because the person, he or she is not your tenant, so properly called.
Tenant.
The law further asks or grants the applicant the power to obtain a copy of the tenancy agreement.
Upon request.
Upon request. So where my husband who's been evicted was paying 1,000 cedis. You don't come and tell me now it is 1,005 because he's
you want to revise
because
it.
you want to revise
but
it.
It's possible that the evicted husband may still be the one who has to be paying this
yes.
rent anyway.
Yes.
So
The protection orders include maintaining the victim, as it were, until such time as the court deems fit, or until the tenure of the order.
So you maintain the status quo. It's just that your address changes.
Yeah.
So every other thing you were doing before,
You
including paying the rent. So it's like I've been kicked out of the house. I'm still paying rent for a place I don't live in, and I still have to pay for the upkeep of the people in that house.
You brought it onto yourself.
This is serious. So in a situation where boyfriend, girlfriend are living together, and there's violence, and perhaps the man goes for occupation orders, and the lady is kicked out. Now, do you have enough rights for me to continue to be paying to maintain you?
So it depends on the court in making this assessment. Looks at the relationship you had, the duration, how the relationship was. If these were things that were present during your relationship, so if it's even though you were not married and you were just courting, you took it upon yourself to give your girlfriend an allowance of 1,000 cedis. Who is the court?
And she's living in your house.
And she's living in your house with a key and all. And now, because of your actions, you have to leave the house because the occupational order is not limited to a matrimonial home. The Act provides.
But that is where the problem is.
Home.
It's like you're carrying a problem that is not yours.
Well,
you brought it onto yourself.
You've adopted her, essentially.
Yes. And so who is the court to stop that arrangement?
No, but the court cannot force you to continue to
be in the relationship.
So you can say that, okay, I've broken up with you.
This is where we end.
So wait, you don't want to do again, but then whilst the proceedings are on, would the court insist that you continue to pay the rent and maintain?
So that's what I'm saying, that the act that you have done is a crime.
Yes.
The court can still exact criminal sanctions
on that act.
But if subsequent to that you say, okay, I've broken up with her, I don't have any relationship with her, then you may not come into the ambit of the Domestic Violence Act for the the maintenance. But what you have done in the past was a crime. And the court can continue to punish you for that crime.
So the court will proceed to prosecute you on the crime you've committed.
Yes.
But now that you've been thrown out of the home you rented and then you were living with her in, what happens?
If you break, you can go back to the court for a variation of the order.
Once you break up, okay, and you go for a variation, what exactly will be that she now leaves because you've broken up, so I want to take back? Because
if I was
this
a
is
lawyer
a place
for the
you
man,
want to continue
if
to
I was
be
a lawyer for the man, I would go and tell that before we started dating, where were you living?
Exactly.
That's the question I'll
because
ask.
the occupational order does not give you any proprietary interest in the property.
Yeah.
But then essentially,
so you are just a tenant by law. But
she's
once that
being
changes,
punished, okay, so she's losing twice, or he's losing twice for reporting the crime, and now you've lost the relationship. Okay, fine. For acting that way, clearly there shouldn't even be any relationship
in the first place. Yes.
But then she now would have issues with where to go
immediately. That is where it makes it difficult for victims to report. The scenario we are just discussing, we may be discussing it lightly.
Yeah.
But in real life, the economic consequences is what make people very slow to report.
Because many people are in relationships because of
the economic
comfort reasons. Yeah.
And it may not even be intimate, like boyfriend, girlfriend, or husband and wife. Even
brother,
father,
sister, father, mother.
If your big brother is the one taking care of you, or if your big sister is the one taking care of you, if she emotionally or verbally abuses you, and you go and report, they'll ask you, okay, fine, it's not my obligation, it's not my responsibility, like you said. What I have done is a crime, I'll deal with it, but who pay your school fees?
That's where you get stuck.
This is where a lot of people get stuck. And our economic, or as a country, we do not have those kind of arrangements where
shelter,
victims that will embolden them, so that if you walk to the police and you say that, listen, this is my economic situation, this is what I am facing, but because of my economic situation, I do not know what to do. Would the Ministry of Gender and children welfare be able to say, okay,
listen, we don't even have enough shelters for the destitute as we speak now. So we have some questions from social media, and let's try to answer them, and then we continue with our conversation.
My name is Nana, a primary 6 pupil. My dad keeps beating me for not doing well in school. I am not very happy with this attitude of my dad. Can I take him on and get him ejected from the house? So it's just with my mom and I in the house. He keeps abusing us. I want him out of our house.
In answer to Nana's question, as a minor where he is abused in whichever form, he does have a right to make a complaint or to start an action for domestic violence against his father. In respect of that, the issue of the occupational order can be determined by the court. As you've already stated, in making the order, the court has to balance a lot of things. As he's rightly said, he is a student. He's not indicated the capacity of his mother to look after him and his siblings should this order be granted. He's not even stated where his father intends his father to go. And these are all considerations the court will make before such an order will be made. It's not as simple as saying there has been an act of domestic violence and so I should be ejected. The act provides a very stringent test which has to be satisfied, and the court must satisfy itself so that justice is done, not just seen to be done in this instance. I'll ask Bobby to...
Well, the only thing I would add is that, yes, in such situation, we also have to be very realistic. The court has the right or has the jurisdiction to order your father to leave the house. But the court does not have the jurisdiction to order your father to pay your school fees. The court cannot force your father to pay your school fees. The court can order your father to leave the house. You would have to weigh the situation. It's wrong, it's not acceptable, but if making or applying for the court to eject your father from the house will not achieve the purpose for which you want it, then you should look at other options available in the law. Because there are other options. I mean, the occupation order is not the only order that is available in the law. So you should look at the other options that can still protect you from this violence, and your father will not have any basis to say that I'm not going to pay your fees.
I am a house help for this man. He abuses me and it's just the two of us who stay in the house. He takes my salary sometimes and abuses me on top. Can I seek occupational orders in this circumstance?
So in those instances, you are an employee. You have contracts of employment, whether verbally or in writing, which indicates what your rights are as an employee. If the employer, even though you live in the same house, decides to abuse you, you can decide to terminate the employment and sue for your rights under that employment agreement. And that's why I'm saying that the fact that we are speaking about occupation orders doesn't mean that is the only remedy that the law allows you in those instances.
This is somebody who wants occupation orders, okay?
It means that you want to take over somebody's house.
But, per the Domestic Violence Act, that person will fall into that domain.
Well, it's a discretion
because
that the court will exercise.
it is not really a strict employer-employee situation. This is in a home setting, and the law permits that you can go under the Domestic Violence Act for remedies. So assuming she's like, yeah, I'm being abused, I was brought from Burkina Faso for this, I have nowhere to go, I've lost, or I was a refugee, you took me in to work for you, and now this is what is happening, I don't have anywhere to go. Please, court, can you kick my boss out and let me take over her house?
This is what I'm saying, that the court, this is not a means by which people will now, the court will weigh the two. Is it easier and more convenient for you to leave the house?
Yeah.
And then for your boss to pay rent for you somewhere else? Of course, when that happens, it means that you break the employment relationship.
Yeah.
And so the court will consider this. That's why I'm saying that there are
Maybe
other remedies.
Something to settle you. Go rent your own space.
There are other remedies available under the law.
Occupation orders, although available as remedies in some exceptional circumstances within the sphere of the domestic relationship, are not usually taken lightly by the court. Of course, investigations have to be conducted, and the peculiar circumstances surrounding the request or the application would be looked at as well. We've been discussing occupation orders today on Law Express. I was joined by Kwabena Frimpong-Mensah and Bobby Banson, all private legal practitioners, as my co-panelists. My name is Noella Seidu. Thank you for staying with us. Goodbye till next time. This has been Law Express.